An ounce of prevention is worth a pound of cure. Some of the companies that have not gotten themselves in trouble do not always understand how difficult it is once they get tagged with a real compliance problem.
Hello, and welcome to a very special episode of FDA Watch. We're the leading independent, nonpartisan podcast on FDA. I'm your host, Wayne Pines. I'm very excited about this episode. It's another installment in one of our signature multi-episode series that we produce in collaboration with organizations such as law firms. Today's episode is the third in a four-part series we're doing with the law firm Skadden, truly one of the best-known food and drug law firms. The four-part series is called FDA's Regulatory Revisions, Business and Legal Impact on Industry. And we're going to focus on the cutting-edge business and legal issues facing FDA-regulated industry. In part one of the series, we covered the impact of pharmaceutical and biologics regulations. In part two, we discussed the impact of FDA regulation on medical devices. Today, we're going to talk about foods. And I want to remind you, if you want to listen to the previous episodes or any previous episode, you go to our website. It's fdawatch.net, fdawatch.net. And if you have not subscribed, we'd appreciate your subscription. That enables us to know who's listening. But beyond that, you will then get an email whenever a new episode comes. And you'll also have access to our resource link. So it really does help to subscribe. Let's meet our guests. First up is Rachel Turow. She is head of Skadden's FDA regulatory practice. She has almost 2 decades of experience in food and drug law, deals with a wide range of FDA issues. Rachel formerly was regulatory counsel at FDA and also served as in-house counsel at a number of multinational companies. Welcome back.
Thanks so much, Wayne. Great to be here with you today.
Also joining us today is Milli Hansen. She's a partner in Skadden's Mass Torts, Insurance and Consumer Litigation Group, where she has significant experience at coordinating and managing large-scale or multi-jurisdictional litigation, such as class actions, multi-district litigations. Welcome to FDA Watch, Milli. Good to have you here.
Thanks, Wayne. So happy to be with you and your audience today.
Dan Lux is a partner in Skadden's Mergers and Acquisitions practice. He advises public and private companies, as well as private equity sponsors, on mergers, acquisitions, corporate governance, dispositions, securities offerings, and other corporate matters. Welcome to FDA Watch, Dan.
Thanks, Wayne. Really looking forward to the episode of FDA Watch today.
And Doug Stearn. He's a nationally recognized expert in food and drug regulatory compliance and policy, has more than 30 years of experience at FDA and the Department of Justice. He spent 17 years in senior leadership roles at the FDA, most recently as Principal Deputy Associate Commissioner in the Office of Inspections and Investigations. He is now a principal at Canal Row Advisors. Welcome to FDA Watch, Doug.
Good to be with you today, Wayne.
So I want to start out with a very broad question, asking Rachel and Doug to comment. What do you see going on in the food area at FDA and in the States? Particularly, what's changed in the last year since the advent of Dr. Makari's coming on? He's just celebrated his first year anniversary. And how are all the changes impacting industry? Let me start out with Rachel and then ask Doug to comment. Rachel?
There definitely has been a lot of change at FDA in the current administration in the past year. I think the most interesting aspect of the change has been watching the political agenda, especially as it relates to the focus on healthier eating, the rebuilding of or the flipping of the food pyramid, I should say, the focus on things like food dyes and certain types of dietary supplements has really highlighted the limitations of FDA's regulatory authority in this area. It's also been very interesting to watch how FDA and the states have collaborated on a lot of these issues around food safety, food ingredients, dietary supplements, and how industry has tried to navigate the patchwork that has emerged between state law and state regulation, and FDA's both podium policy and regulatory agenda. And I think, watching kind of how FDA has asked for voluntary compliance in a lot of these areas rather than taking direct regulatory action via, notice and comment rulemaking or issuing guidance has been, I think, sometimes confusing, sometimes challenging to navigate, especially, for example, the way FDA kind of asked for voluntary compliance with removing petroleum-based food dyes from foods instead of, and also kind of coupling that with rulemaking. It's been an interesting juxtaposition to watch how the agency has navigated this area, especially given how ambitious its agenda is as compared to the size of the food program. And I know Doug knows about that a lot, more than I do firsthand. So I'm sure he has some things to say.
Thank you, Rachel. I think one of the things that I would say is that I think it is important to look back a little bit, even as we're talking about how things have changed. There has been a resource problem at the agency, and it has been especially pronounced within the food program. And that's been going on for a long time. Center personnel, that is personnel in headquarters, have been relatively flat for a very long time. The field activity personnel has been flat and actually declining recently somewhat. So that has all been going on. And at the same time, there's been additional things put on the food program for it to do and to rise to the challenge. And this administration and this leadership has things that they do want to do. And I think some of the ways in which they're going about it, it really does help understand that they're doing it within a time in which there are real capacity problems in terms of meeting those expectations. And that's also something to keep in mind as we look at how that gets done. And I see that in the food safety area with regard to microbiological safety and with regard to chemical safety and the regulatory issues that Rachel had mentioned. And so I can go into all of those, but I do think that's really part of what has helped shape some of the landscape that we're looking at now.
In terms of the resources, Doug, what particular areas of the food program are you concerned about that may be even more significantly underfunded and understaffed? We've talked about in the past about infant formula, talked about inspections. What particularly concerns you there?
Well, I have concerns in a number of areas. So, one thing to look at is sort of the traditional area where FDA has spent most of its resources and people, which is microbiological food safety, which, we have the Food Safety Modernization Act. It has a whole series of things that FDA should be doing. It has high levels of expectations regarding inspectional coverage, which FDA has struggled to meet. It has never met the expectations that Congress had related to foreign food inspections. Domestic inspections has been a challenge. And there's also all sorts of other activities that have gone on that are also relevant to that, the kind of guidance that's needed. There's a slew of different regulatory actions that have been needed in order to develop that, which have been slow. And if you look at the chemical food safety, that has really been an area that we've had no designated budget to do a lot of the things that the agency currently wants to do right now, which is to take a look again or to change a lot of what's happening in terms of the access or availability or perception of different food additives. There has not been a program until very recently really to look at that. Currently, if you look at what's on the website, there's maybe 25 to 30 chemicals roughly that are being looked at. And I think one thing that people don't always understand is these reviews are very difficult because they're often dose dependent. There's the old reference that toxicologist makes, which is the dose makes the poison. So part of it is to understand how much people are getting of a particular substance. If they're novel, they're not always well understood. So it's important to take a look at that. And some of the science is not always clear. And they rely on other work that gets done by CDC and NIH sometimes in terms of the overall level of substance that's accessible. And it's also difficult because it's not like a trial where people are undergoing placebos and the issues can be isolated in the same way. So that's all been I think, a real issue for the program. I mean, and this is, I think, some of the questions or challenges or uncertainties in the future reference that. And finally, and I think Rachel made reference to this to some degree, which is that the regulatory process is slow. It requires a lot to be able to muster the kind of record needed in order to get a regulation through. And that affects all parts of the program. And of course, we're also in an administration that has an executive order or orders that discourage regulatory changes. So that puts some real challenges in how you're going to move things along. And I think the result of that has been to have some of these alternative ways to try to get things done, which include pushing states to do particular issues or with the blessing of the administration to, take action on particular chemicals or to do more inspections that way, or to rely on alternatives to traditional regulation in order to get their objectives accomplished. And so I think that's what I'm sort of referencing.
Yeah, Rachel, I want to ask you about voluntary compliance. We've seen across the board that FDA announcements of new policies, but as Doug just mentioned, and I think as you just mentioned, there aren't any formal regulations to back them up or to explain what the agency really wants. How do you advise clients with regard to the voluntary compliance atmosphere that now exists at FDA?
I think it's really challenging for the industry right now. To a certain extent, the industry is somewhat self-regulated. There's a lot of the remediation and inspectional activities go on either through self-audits or private third-party inspections, much more so than regulatory inspections. So I think that's been going on for a long time, and the industry, the food safety professionals in the industry take this very seriously, and I think do really try hard to ensure that safe food is reaching customers, right? That's the most important thing. And this is in lots of different areas of FDA regulatory law. You have to make risk-based calculations, right? What is the best thing for the business in the context of the regulatory environment? Here, some of the requests for voluntary compliance have come with a lot of political weight. And I think that the calculation has been much less about science and safety as it has been about headlines and avoiding public shaming, avoiding potential lawsuits due to kind of statements made by regulators that are somewhat inflammatory, which is not something that I think we've ever had to navigate before. So all of those different pieces have to go into the calculus right now. It's not just about the science anymore, which makes things a lot more complicated, I think, for Milli and Dan as well in their practices to kind of really triangulate all of these things and what do these risks actually mean for the overall business.
I want to ask you about two specific efforts. One about ultra-processed foods, the definition, and secondly about the effort to reform the GRAS policies. Just address them very briefly. Where do you see those two issues headed?
Doug, you want to take that?
Well, I might start a little bit. I guess it raises a lot of questions for me. First, as I mentioned, the chemical safety process is a resource-intensive process. It has been. And so there is this effort to try to have FDA review perhaps thousands of GRAS notifications. And it's unclear to me, at least, how that is going to happen. The FDA has challenges even in a much smaller notification process in dietary supplements. And so it really does raise a question without a dramatic change in the agency, how that's going to get done. And, with regard to the other issue, which is ultra-processed foods, I think one of the questions is, where does that lead? How is that going to be used? Traditionally, in the nutrition area, the issue has been labeling. And I think it's still an open question about how ultra-processed foods as a label, or how that would be used in a labeling regulation or regimen that would actually affect the diet.
I want to bring in Milli and Dan in a moment, but I want to ask both of you one final question as part of this segment. And I want you to take out your crystal balls, give you a second to do that, and tell us, what do you expect in the coming year with regard to FDA? And the second part of that question is, what are you telling clients, companies, how to prepare for the next year or so? Rachel, let me start with you and then ask Doug to finish up here with this segment.
So I think we're all following the Make America Healthy Again agenda pretty closely, especially given the midterms this year. That's been a huge influence on FDA's policy in this area. I think the Associate Commissioner for the Human Foods Program has been very active lately. He's been out there speaking and announcing all sorts of different policies and talking about FDA's agenda. So I think that has to be number one, is just kind of watching what they're saying to kind of read the tea leaves. But ultimately, I think we're going to continue to see implementation of the agenda that the secretary set out, which is pushing for removal of certain ingredients and eliminating the GRAS loophole, as you were talking about, and really trying to create a review process at FDA for food additives that never existed before. That, if that succeeds, it is going to be a real wake-up call in terms of how to get through that FDA process. And I think it's going to be bumpy, as Doug indicated.
I think one of the key questions is the details on all this, which really will matter. I have a lot of questions about how the whole agenda is going to go on the ground. I think it's important to take a look at some of the things that are going on and to get some additional detail. My hope is that some resources can go into some of these issues so that we can have something that's more authoritative, both from the scientific perspective and the regulatory perspective, so that there's a little bit more clarity, because it is important for everybody to understand, where we are going and to be able to prepare for that. For example, in the inspection area, it's important for us to understand all the field activities that are going on. State inspections or inspections are one component, but there's a lot of other things that FDA does that are really important, including, large-scale sampling assignments. Those are often out there to help understand issues that industry doesn't understand why particular things are happening in terms of a hazard and a commodity, and to be able to get more clarity about that. Those are important to be done. Also, reports on outbreaks and while they're happening, those are important. And when we're looking at inspections, what kind of inspections, how long are they? It's really not enough simply to understand the number of Form 482s, that is the initiation of inspections that have been started. And then on the other side, I'd hope that we be able to get something practical that would focus on the real hazards that are out there. A lot of those are environmental hazards, which have not been discussed too much, like PFAS lately. And, being able to give real answers to people who have questions about that, about what the actual hazards are and how to deal with them, is something that a lot of people have questions about.
Let me bring Milli in here. Milli, how does the regulatory environment impact litigation?
Yes, happy to jump in here. Look, I don't think that I'm saying anything new when I say that regulatory uncertainty in many instances creates litigation opportunities for both state attorneys general and the plaintiffs' bar. And this is certainly no different for the food and supplement space, where ambiguous standards or gaps created through enforcement discretion can be filled by states or private attorneys. Or in some instances by private attorneys acting on behalf of states on a contingency fee basis, which we see a lot of. But really, anytime there's any sort of regulatory vagueness or indecision, or even explicit regulatory flexibility, we see that creates an opportunities for states and plaintiffs' counsels to step in. There are instances in which a company might arguably be in compliance with the regulations or with what the FDA wants from it, but it is still a target for litigation in which it is alleged that that company failed to disclose a purported risk or made some sort of misleading claim. And I'm happy to go into some examples here, but really the point is that I think we're operating in a period in which there's a widening gap between kind of federal regulatory uncertainty and an aggressive plaintiff's bar.
What would be an example of that?
Yeah, so, one example, there's been a lot of discussion about the MAHA movement and its impact on federal food policy, and Rachel mentioned it just a minute ago. One recent policy change relates to artificial food color, and I won't belabor this point because I think it's probably well known here, but the FDA stated that companies will now have the flexibility to claim products contain no artificial colors when the products do not contain petroleum-based colors. So this is a policy shift that's encouraging companies to use kind of natural or plant-based colors in their food products instead of petroleum-based colors, which would still potentially be subject to FDA enforcement. But the policy doesn't actually change any statutory definitions or create any sort of safe harbor for labels with these sorts of claims. So food manufacturers still very much need to watch out for complaints from plaintiffs' attorneys or state regulators that a claim, that a product contains no artificial color is misleading if the product contains naturally derived colors. If I may, I can give one more example. One place that we're seeing a significant litigation in the absence of kind of clear federal direction is with ultra-processed foods. Doug just talked about that a little bit ago, and some of the definitional issues and corresponding kind of regulatory concerns in that area. I'm sure this audience is familiar with the litigation, as it's even broken through to lay audiences and others, but I think it still bears discussion. The case that made a big splash at the end of last year was brought by the city of San Francisco against a number of manufacturers of ultra-processed foods taking a step back, though, that wasn't kind of the first significant lawsuit targeting ultra-processed foods. Most famously, I suppose there was a long-running case against a national chain in which a group of teens claimed that eating fast food caused their obesity. And that case took a long time in federal courts and ultimately didn't get anywhere. More recently, though, the first major suit kind of squarely taking aim at the UPF industry was filed in 2024 in Pennsylvania State Court in Philadelphia. That complaint was filed on behalf of a single consumer who claimed that he developed type 2 diabetes and other health issues as a result of consuming UPFs. And he claimed that the food manufacturers knew that the food, they were selling was harmful and addictive to consumers, but that they sold it anyway. It's really very akin to the allegations leveled against tobacco companies decades ago. And the complaint very much reads like it took many lessons from the big tobacco playbook. That Pennsylvania suit was ultimately moved to federal court and dismissed last year for failing to allege specific causation. And to break out of that litigation speak for a second, no specific causation just means that the court found that the plaintiff hadn't sufficiently linked his specific injuries to the specific conduct by the defendants. So the court, said that even though the complaint was over 140 pages long, nowhere did it say kind of what he consumed, how much he consumed, the time period in which he consumed it, such that it could be linked back to his injuries. That plaintiff has proposed an amended complaint, which is pending before the court. It is a whopping 473 pages long. So we'll see where that goes. But going back to the San Francisco case that I just mentioned a second ago, it's, the complaint is very similar. And in fact, it's brought by the same plaintiff's lawyers that brought the Pennsylvania case, but it's different for a couple of reasons. One, it relies on California state law and a particular unfair competition law, and the government doesn't need to prove specific causation there, which is really what hung up that Pennsylvania court. The San Francisco case also relies on a public nuisance theory, which is traditionally a claim that really arises in the context of property, but has been popularized in the opioid litigation and some other litigations to address purported social harms. So it'll be interesting kind of to see how that develops. And the stakes are quite high, given the amount of penalties available to the government should these manufacturers be found liable.
Do you overall see a more active plaintiffs' bar in the food safety area?
Well, I see an active plaintiffs' bar in a lot of areas, but the food area certainly hasn't missed that bar.
Is it more active now because of the statements being made by government officials than, let's say, a year ago or 2 years ago, or the plaintiffs? Is a plaintiff's bar jumping on a lot of these statements, as you've indicated, talking about ultra-processed foods and the like?
Yeah, absolutely. I think companies really have to pay close attention to kind of the podium policies that Rachel mentioned earlier and kind of other forms of the soft FDA guidance, because even if those informal statements don't carry the force of law, if Secretary Kennedy, articulates a position, I very much expect to see that theory tested in a consumer class action in short order.
We're going to take a quick break now. I want to get Dan involved and talk about M&A deals. That's going to be my first question after we take this quick break. And we're back talking to Rachel Turow and Milli Hansen and Dan Lux from Skadden, Doug Stearn from Canal Row Advisors. First question, bringing you in, Dan. One of the biggest issues, of course, is M&A deals and how they're affected by this regulatory environment. Can you address that? That's your sweet spot there.
Thanks for bringing me in, Wayne. So I would say on the whole, uncertainty and regulatory changes and regulatory challenges are typically bad for deal making. I think they're really two different considerations here. One on the buy side, and then a very different set of considerations for sellers pursuing a sale transaction. So for buyers, I think what the current environment means is that there needs to be and should be a much more significant focus on diligence and understanding what the regulatory landscape looks like and potential changes that are coming, and really at an early stage in a process beginning to focus on that. As I think Rachel mentioned earlier, companies are now facing a patchwork system of state and federal legislation that isn't typically seen in industries maybe other than outside of heavily regulated industries, where you have food products that are being sold across a significant number of jurisdictions. Potential buyers of a company need to really make sure that they make an early assessment of their risk tolerance and their ability to operate in a less than certain regulatory landscape. I've seen buyers who are just willing to accept that regulatory uncertainty is a cost of doing business. But I've also seen buyers where they're not really willing to participate in an industry where you don't know how what regulations you'll be subject to tomorrow. And I think that that's the challenge that a lot of parties are facing in today's food and beverage market. I think what practically speaking that means is that buyers very early on really should be looking to their food regulatory counsel and leaning on them to really understand what things look like today, potential risks that exist, and what potential changes are that could actually impact the value that a buyer is trying to obtain from a target business. I think really doing this will allow buyers to better and more comprehensively understand the potential risks and the trends in a given space. Doing diligence at the last minute in this context, it's not going to really allow a buyer to understand exactly what the challenges are and whether or not a potential target is up to meeting those challenges. And so it's really just a question of having that additional time early on.
Yeah, we've seen uncertainty across the board, I think, at FDA. It's going to sound maybe like a strange question. Is uncertainty permanent now? That is, we've seen a new administration coming in and create a level of uncertainty that perhaps we haven't seen for a while because of a few people who have views about the food supply, or in the case of drugs and devices. That could happen again. That could happen repeatedly. Is the uncertainty a permanent feature of our? Is uncertainty a permanent feature of our regulatory environment?
I don't think it's necessarily a permanent feature. It's obviously going. It's going to in part be a byproduct of who who's in the White House, who's at the FDA. And even if uncertainty persists at some point in time, I think on both the buy side and the sell side, parties just kind of accept that as the new normal and really have to figure out a way to operate within that system, right? And part of that is being nimble, being able to anticipate change, kind of thinking a few steps ahead. And look, in the past, maybe companies they knew what legislation was coming down the pike. I mean, parties knew how to prepare for the Food Safety Modernization Act, but it's not as though companies in the space could just not do anything to keep up with coming changes. And so, look, I think uncertainty presents certain challenges, but at a point in time, at least what I see on the M&A front is that for parties who want to continue to do business, it's just that's kind of the nature of what they have to accept.
And what would it take to remove the uncertainty? What would a buyer, let's say, if you advise
Mm-hmm.
buyers, what would you say and say, oh no, uncertainty is not a factor for you
Yep.
because such and such is happening. What's such and such?
That's a great question, Wayne. And I think it's hard to see the uncertainty, being removed completely. But what I think it is finding a target with a management team who really can show that they're being proactive and that they're always trying to stay ahead of potential regulation, that they're in constant contact with with their food safety and regulatory counsel, and that they're preparing for whatever the future might be. I remember doing deals maybe a decade or so ago, and there were always questions in diligence about food labeling and calorie counts and how companies are preparing for the Food Safety Modernization Act. And it was very clear that yes, there were changes that needed to be made in certain businesses, but when you had a management team who was all over those potential issues and challenges, I think those are the kinds of things that give a buyer a lot more comfort, even though that uncertainty itself still remains.
Right. I have one final question I want to ask all of you to answer the question, and it deals with the future. I know Rachel and Doug addressed that a little bit before, but what should companies be doing about this new environment that we're in? What kind of advice do you give your clients in terms of the best ways to navigate what I think we all seeing? We've described changes at FDA. We've described increases in litigation, described uncertainty in the M&A area. What do you advise your clients in each of those areas? I want to start with Rachel, and then Doug, then Millie, and Dan. Rachel?
Thanks, Wayne. I think similar to what I said before, it's really important to stay on top of where FDA is going and what their real enforcement priorities are. That's the best way to take a risk-based approach, which I think is the only way to manage through this kind of environment. And then avoid the stupid mistakes. I think there are places where, there are certain claims, as Millie was talking about, that are really hot button for the plaintiff's bar. There are certain areas with respect to labeling where, really good processes are of paramount importance. Choosing really good contract manufacturers, those kinds of, basic things can really be protective from a regulatory standpoint and really help a business overall. So I think, making sure all of those ducks are in a row, and then obviously keeping up with the ever-changing trends is the most important things right now.
I would say it's really important for companies to stay a step ahead. I know at Canal Row Advisors, a lot of us talk about how when we were at FDA, we used to say that you should not rely on FDA as your QA system. And I think that today that comes with an explanation point. With FDA stressed, companies need to make sure that they're on top of things. If a facility gets tagged with an unacceptable status, it's going to be more difficult in those circumstances to make sure that it gets addressed. You don't know if it's going to be an agency priority necessarily in relation to all the other priorities. And that also goes for your suppliers and making sure that, you don't get caught with somebody else's mistake. So an ounce of prevention is worth a pound of cure. We really think that it's important for companies to stay a step ahead of that. I think that some of the companies that have not gotten themselves in trouble do not always understand how difficult it is once they get tagged with a real compliance problem, because that just makes it very difficult to undo. And if FDA is challenged or focused on other areas, that's not necessarily going to be helpful for you to get out of that situation.
Millie?
I think Rachel and Doug made some good points. From a litigation perspective, food manufacturers can't just rely on compliance with federal or state regulatory guidelines. Instead, I think companies really have to assess the risk level and their own risk tolerance for state and private litigation in this space. These litigation actors, the state attorneys generals and the private plaintiffs bar, are really pushing forward theories compelling certain warnings on labels, and effectively banning certain ingredients by attempting to create liability for manufacturers that use them, even if those ingredients are allowed. They're also pushing tort and consumer protection theories based on how food is processed, like we talked about, and seeing what the limits are of nuisance theories that are premised on recovery of costs incurred by the public from these purportedly harmful products. And so they really have to kind of keep their eye on this broader litigation risk, even if they are in compliance with the law.
Dan, what do you tell an M&A? Somebody who's coming in, company wants to be acquired or wants to acquire another company, uncertainty environment. What do you tell them?
I think on the sell side, it's really making sure that you've self-diligenced, that you you understand the landscape, you understand what potential risks exist. You speak early and often with your regulatory counsel, so that when you're actually going through a sale process, a buyer is not going to uncover something that ultimately could derail a deal. And I think on the flip side for buyers, it's just making sure that you're heading into a transaction really with your eyes wide open and understanding that the regulatory landscape can change on a moment's notice, and are you comfortable with that risk?
And certainly, I think we can all agree that in this area of uncertainty and change, we live in interesting times. And I think it keeps all of us busy these days. So on that note, I want to thank our guests, Rachel, Milli, Dan, Doug, for informing us about this. This was a very good session, and you addressed all the issues very, very nicely. I think it really is, interesting times. I want to thank our podcast creator and executive producer, Michael Evan Epstein, our assistant producer, Sam Hoffmeister. If you want to find out more about the podcast, as I said earlier, visit our website, fdawatch.net. You can pick up all of the previous episodes. We've been around since January of 25. We have a final installment in our Skadden series coming up. And the best way to know about that is to subscribe. You go to fdawatch.net and you'll see a subscribe section there. You just put in your email address and you say submit, and you'll be able to subscribe. So as I say at the end of every episode of FDA Watch, if you really want to watch what FDA is doing, listen to FDA Watch. This is Wayne Pine signing off.